morning, everyone. My name is James Good. I'm an Assistant Principal Officer in the Anti-Money Laundering and Compliance Unit, or the AMLCU, in the Department of Justice. I'd like to welcome you to this morning's webinar, which will provide you hopefully with an overview of your obligations and responsibilities as designated persons under the Criminal Justice Money Laundering and Terrorist Financing Act of 2010 as amended. The AMLCU itself was established in 2010 following the enactment of the Criminal Justice Money Laundering and Terrorist Financing Act of 2010 as amended. The Act established the Minister for Justice as a state competent authority and as a competent authority for the purposes of securing compliance by certain categories of designated persons with statutory requirements to prevent money laundering or terrorist financing. Under the Act, the responsibilities of the Minister have been delegated to the AMLCU, and we are responsible for supervising relevant designated persons. As such, it supervises the following categories of non-financial businesses and professions: high-value goods dealers, trust or company service providers not otherwise supervised, notaries, external accountants not supervised by the prescribed accountancy bodies, gambling service providers, and tax advisors not otherwise supervised. The AMLCU supervisory process includes inspections conducted by a team of regulatory investigators, one of whom is going to give you a presentation after myself on the inspection process. We've a number of presenters this morning, so it'll be a busy enough session, an hour, and hopefully it'll be beneficial for you. The presenters today will be John Conway, who is a regulatory investigator from the AMLCU, who will discuss the inspection process with you. Aisling Hoy will then follow John. She is from the Revenue Commissioners, who will discuss the suspicious transaction reporting process to revenue. Aisling will be followed by Detective Sergeant Clodagh White from the Financial Investigation Unit of the Guards, who will discuss Go AML and the potential risks for tax advisors. And Clodagh will then be followed by Patrick O'Connor from the Revenue Commissioners, who will discuss the Central Register of Beneficial Ownership of Trusts, or CORBOT. There will then be a Q&A section at the end, and if you'd like to ask a question, please feel free to submit it throughout the webinar using the Q&A function at the bottom of the screen. The webinar is being recorded and will be available in due course on the AMLCU website, which is www.amlcompliance.ie. And on that note, I'm now going to hand you over to John Conway, one of our regulatory investigators, whose presentation will hopefully give you a good overview of what you could expect if you're going to go through an inspection. John, I'll hand it over to you.
Thanks, James. Yeah, so I'm just going to go through some slides here on basically the process of an inspection and what we would expect to see in a compliance inspection. So this is there's going to be a lot of information on the slide, so I'll just go through the slides to be available afterwards anyway. So the legislation is Criminal Justice Money Laundering and Terrorist Financing Act as amended, and basically we're responsible for the compliance inspections. So we take a risk-based approach to supervision, which means that while we try and hit everyone, we take a risk-based approach in terms of our cohort as to who and how often we will inspect. The length and the format of compliance inspection, the format is basically we will look to see how you're actually implementing your obligations. So that's evidence-based approach on how we do it. And normally what we do is we have a questionnaire that we run through. The length of the inspection varies. I would say the minimum would be maybe half a day, but it can go on. It all depends on the size of the business, the complexity of the customers, and the evidence there. So once the inspection is done, the regular inspector will draft a report, and that will go to the competent authority for sign off, and there will be follow-up then normally in terms of directions or recommendations to improve compliance. So the actual process itself, you will receive a notification of inspection. Normally by post, and you may be required for certain documentations to the unit prior to the actual inspection. This helps us basically get to know your business a bit better before we actually arrive on site, and we have an idea of who your customers are, what risks you've identified, and what policy procedures you have in place. So on the actual day itself, the inspection will take basically look at the details of the tax advisor, how you do things, and the ownership and any other relevant details. We'll look at your business risk assessments, the policies and procedures you have, and we look at any staff training you provided. And we'll also, most important and probably the most detailed part is actually an examination of the records that you have there to demonstrate compliance with the Act. Well, so a lot of that would be your customer risk assessments, how you assess your customers, the customer due diligence forms that you collect, such as your ID verification, sorts of funds, well, the ultimate beneficial owner documentation, and I suppose the ID verification, that's normally proof of address and proof of ID, a government issued ID. And the ultimate beneficial owner documentation is any checks of any registers, such as the CR bot or the RBO register, and also what information you've done to validate that you do actually know the ultimate beneficial owner. After that, we have a look at if you've encountered any suspicious transactions and how they were uncovered, and whether they were reported or not. And finally, at the end of the inspection, if required, we'll draw up an inventory of documents that you should supply to us. If we're taking physical copies, we'll get you to sign for them, or we'll get you to forward them electronically afterwards. So after the inspection, then the authorized officer will review the inspection material and the evidence provided, and we may have additional follow-up questions just to clarify issues. The report will be drafted in for the competent authority, so they will assess the findings and recommendations, determine what level of compliance and what corrective actions, if any, are required. So there's 3 levels. There's you could be found compliant, which means on the day that you were found compliant with the Act, partially compliant, and non-compliant. So non-compliant would be that you haven't implemented one or more of the obligations, and partially compliant would be that you have, but you haven't implemented them effectively. So following this, a letter with the finding and directions will be issued, and a date by which the corrective actions must be implemented will also be put in there. After that, I'll just go through the actual obligations themselves. So one of the most important bits, as it is a risk-based framework, is to actually have a business risk assessment in place, and this is a tool to assist you identify, assess, and mitigate the risks to your business. So if you look at section 38, there's a list of risk factors there. We do have a template also on our website for 1 or 2 of the other cohorts that may be useful. And it should be an honest appraisal and recognition that risk exists. I mean, there's no such thing as no risk. The only way you can have no risk if you're not actually providing service. So, I mean, there will always be an element of risk. So it's just to be, to make sure that you know what level that is. There's also Schedule 3 and 4 of the Act. Schedule 3 is the risk factors that are considered low risk, and Schedule 4, the risk factors considered higher risk. So once you have completed your risk assessment, you should have an overall risk rating for the business, which would be low, medium, high, or high. And it should be carried out on an annual basis, reviewed and signed off by senior management. So I always say, it's like, I don't know if anybody remembers it, that's the Dr. Pepper approach. What's the worst that could happen? So you should consider the service you provide, and then how would those services be abused by someone to legitimize criminal proceeds or terrorist funds. So that's kind of what you're looking, and there's kind of 3 stages you need to consider. Presentation, which is when people are trying to bring money into the financial system. So that's what risks are presented there. Layering then is where people are trying to disguise where the source of funds come. So you might have money being transferred around in unusual manners to try and disguise where the money actually came from. And the final part is integration, and that's where the money has been effectively cleaned and is brought back into the financial system. So you should really be considering at those 3 stages what the risks are with your business. The next part then is the customer transactional risk. So this is the risk posed by the customer and the transactions that you're performing. So again, there's the risk factors are listed in section 30B, and the risk-based approach is to determine the level of customer due diligence that will apply, that I'll discuss in the next section, and that is that simplified, standard, or enhanced. Again, Schedule 3 and 4 of the Act can be used to assist you to score the risk. So you should assign an individual customer risk rating and document the rationale behind the risk rating assigned and why you chose that particular level of due diligence. And a useful tool is maybe to have a customer checklist that so that you can be consistent in your application of the customer risk approach. So once you've got your customer risk assessment done, it's customer due diligence. So there's 3 types: simplified, standard, and enhanced, and that's basically depends on the risk presented by the customer. So the identification and verification of the customers and all relevant parties. So you should know everybody relevant to the transaction. So the ultimate beneficial owner should be clear who that is, and you should be clear if there's intermediaries which may be used to obscure the ultimate beneficial owner. And you should be checking and verifying this with the registers RBO and CRBOT, which will be discussed later, and report any discrepancies. And things to watch out for are unusual forms of ID or proof of address, undue secrecy, or reluctance to provide documentation. So, and you should be aware that persons not cooperating with providing CDD is also a basis for, maybe used as a basis for a suspicious transaction report. So you should consider the source, the customer's explanation source of funds. If you're not happy with that, you should ask for more information. And if you're using third parties to carry out customer due diligence, you must put in place arrangements that can be tested, and you must put in place what's called a reliance letter, and that must be tested regularly. Just make sure that you are being provided the information correctly. And then you kind of come into the your obligations in terms of the examination and monitoring of transactions. So you should always be aware of the nature and the purposes of the business relationship prior to going in, that it does make economic and commercial sense for them to be dealing with you. And, you should monitor it appropriately, depending on the risk associated with the transactions. And you should just be aware of any complex or unusually large transactions or unusual patterns of transactions. So in terms of this, things would be, circular money flows through groups of companies, money coming in from offshore or tax havens, or cash intensive businesses with unusual sales volumes. And a good practice is to baseline the activities you would normally expect to see from a company, and that will give you a basis, to spot any deviations from the norm or suspicious activity. Another part is the politically exposed persons. So this is a person who has been entrusted with a prominent public function, and due to their position and influence, is recognized that many are in positions that can be potentially abused for the purpose of committing money laundering offences, including corruption and bribery. So PEPs can be domestic as well as foreign or non-domestic. So you should evidence any searches that you've carried out to make sure that, to see if a person is a PEP. Senior management must, approve it prior to commencing it, and you should determine the source of wealth and source of funds, and evidence that, enhanced due diligence has been carried out. And a good practice is to have a PEP register, so that you can keep track of these your registers that you have on file. I won't talk too much about the suspicious transaction reports because my colleagues will be doing more on that. But basically, You should have an internal policy procedures to document the procedure from detection to reporting. You should have registered on GoAML and ROS. There is due reporting to the Garda Financial Intelligence Unit and the Revenue Commissioners. And you should have a document explanation as to why an SDR was not submitted if you detect a suspicion, but on further investigation you deemed it not to be a suspicion, and it should be noted that tipping off is an offence. Staff training and instruction. So all persons involved in conduct should be instructed in the law, and appropriate training has been provided, and should provide copies of training materials, attendance records, and information related to the method of delivery and how often is delivered and refreshed. So you should encourage an open environment for frontline staff that promotes reporting of any suspicions. And a good way of training and testing procedures is to review a sample of customer files, once a year or so, and examine whether all the relevant information is gathered and recorded. So that's a good way to actually test your procedures and also test your staff training, and also to train staff in one go. You should have documented internal policies and procedures, and these should flow from the business risk assessment. So they should address the risks you've identified. Section 54.3 puts in place, what requirements should be in a actual procedure. It should be document signed and dated. It should be approved at senior management level, and it should be approved and when required, or on an annual basis at a minimum. And I just draw your point for large organizations, there is an internal protected disclosure policy that must be considered. So you should test the effectiveness of your policy procedures annually at a minimum. So have your end users test procedures for gaps in the process, and look at the content. What does the control achieve? So are you trying to identify risk, prevent risk, or mitigate or control the risk? And the effectiveness. So does it reduce the risk to acceptable levels? And have you had any near misses or incidents where there was a suspicion that was detected, or actually one where it was only detected afterwards? So you should just be testing, that your controls are effective. And I suppose the important part at the end is the actual record keeping. And I suppose this is important because this is how you demonstrate to us how you are actually implementing your policy procedures. So you should keep appropriate records demonstrating how the procedures are applied and information obtained in relation to each customer. So you should be able to evidence the history of services and transactions carried out, and records should be retained for a period of not less than 5 years after last transaction. So you should try and keep an orderly presentation of files and records, because it helps us basically review the files quicker. And I suppose the longest part of any inspection we have is actually the file review. So if you have them in good order, it just makes our life a whole lot easier. And information provided after inspection may not be taken into consideration, but I think at a high level you need an up-to-date risk register and be able to demonstrate how you identify, assess, and review the risks, and records of the senior management review, be that meeting minutes or someone has signed off on it. They should be able to demonstrate an awareness of the AML or CFT obligations at the highest levels of management, and that you have appropriate resources dedicated to it. You should be able to demonstrate how the business risk assessment informs your policy, procedure, and training, and how you've implemented policy, procedure, and training. So how they're actively reviewed, updated, and improved. You should be able to demonstrate controls actively used and the training provided. You should, and this may have log files, incident reports, and you should have reviews of the records. They're saying that you're maintaining compliance. And I think that's the last one. So there will be questions afterwards, but that's a whistle stop tour. And as I said, the slides will be available after, and of course a recording of the video. So back to you.
Perfect. Thanks very much, John. And as John said there, the slides will be available afterwards, and there will also be a recording on the AMLCU website available to watch back. So if you have anything you want to look back over, you can check the recording there. And now, Aisling, I'll hand over to Aisling Hoy of the Revenue Commissioners.
Hi everybody, I'm just going to share my screen here, so just bear with me for one moment. Good morning everybody. My name is Aisling Haughey and I have the responsibility for the STR unit in revenue. I'm sure many of you may have dealt with my colleagues, Niamh O'Grady, who's the manager of the STR unit, or Tony Grant, who I'm hoping are on the call today. I think there was some technical issues on their side. Um, As you're aware, accountants and tax advisors are the key gatekeepers to the financial system, facilitating vital transactions that underpin the economy. As such, you have a vital role in ensuring that the services you provide are not used to further money laundering or terrorist financing. This present today is going to be very short. We have only about 10 minutes, so it'll be a very high level view of what your STR reporting obligations are, how you can submit STRs to revenue, what makes a good STR, what information should be included, how revenue use the STRs when we get them, and finally looking at how you can get more information on reporting or how you can contact us. So STRs play a pivotal role in the fight against money laundering and terrorist financing, and the STRs, the information on the STRs assist ourselves, CAB, the guards in our investigations, resulting in the disruption of criminal activity, the identification of tax evasion or customs and excise fraud, and ultimately can lead to penalties, prosecution or imprisonment. The requirement to submit STRs is contained in Section 42 of the Criminal Justice Money Laundering Terrorist Financing Act 2010 as amended. And this obliges you as a designated person to submit the STR to both Revenue and the FIU once you've formed a suspicion of money laundering or terrorist financing. It should be noted that Revenue isn't involved in the investigation of money laundering. However, tax evasion is a predicate offence. And some of the very high level risk areas that you might, as tax advisors, see could be failure to correct an error or omission on in accounts or tax returns. So where you have pointed out an error to your client and they still haven't corrected that error. Under declaration of income and gains, or overstating of losses and allowances. Um, the designated person, the legislation provides that as this designated person that you must make the report as soon as practicable. So once you become aware or form a suspicion of money laundering or terrorist financing, you should be submitting that STR to Revenue and the FIU. In Ireland, we have a unique system in that we have a dual reporting system so that both the Financial Intelligence Unit and Revenue receive the STRs. We work very closely with our colleagues in the FIU and meet with them regularly to discuss any patterns or trends we think might be of interest to each other. And what an STR does is that it can provide a red flag. So it highlights a pattern of behavior that mightn't be consistent with what you would expect for that client or taxpayer. So for example, if you have a relatively young person with no visible source of income purchasing property, or if you have a PAYE worker who is lodging lots of cash into an account, so it's behavior that is inconsistent with what you would expect for that type of business or individual. Obviously, ourselves and the FIU are looking at STRs from different perspectives. Revenue are looking at it from the perspective of tax evasion or customs and excise fraud. So how do you report your STR? In 2020, Revenue introduced a new online reporting system for STRs. Prior to that, we had a system where the larger financial institutions were able to submit their STRs electronically, but for the majority, it was a system where they had to go on to the FIU Go AML system, input the data there, wait for it to be accepted, print off a copy, put it in an envelope and post it into revenue, where the revenue officials then had to key enter all of the data again. Obviously, this wasn't the most efficient system. So the new online system means that all returns, all STRs are submitted electronically. And you have two options. You can upload an XML file, so it can be a single or multiple STRs in XML format. And you can do this by completing the form as you always did on the FIU GoAML system. And once it's accepted, download the generated XML file to upload it to Revenue. This is probably the better option for all of you who are already familiar with the GoAML system. But you also have an option of completing the web report on ROS. Again, you just complete all of the information on the online form and download the XML file and upload it onto the FIU's GoAML system. It should be noted that the Revenue web reporting system is identical to the FIU's GoAML system. What we did was we merged their system, so we captured the same information. This was to be able to allow the kind of dual reporting, so you wouldn't have to key enter information twice onto two different systems. On ROS, you can save attachments that are associated with the STRs, and you can also receive an online acknowledgement of the STRs that you have submitted. So what do you need to be able to use the service? You need to be registered with ROS. So you have to have your ROS login details and a valid ROS digital certificate. I assume that most of you are already registered for ROS for your other revenue reporting requirements. You then need to register for STR reporting obligations on ROS. And to do this, you'll need your FIU organisation ID number. This is available on the FIU GoAML website, and this is to make sure that all of the STRs are linked to your reporting entity. You'll need a ROS sub-user certificate for all MLROs for STR reporting. It should be noted that the sub-user certificate lasts for a period of 2 years. So once you get it, it should be saved securely on your systems, and you should keep a record of the password that you use, because there might be gaps between when you submit STRs. In 2021, we received over 38,000 STRs, and the majority of these were received from the financial institutions. Over 50 of them were received from the accountants, auditors, solicitors, and trust or company service providers. But if you look here, this is a comparison between STRs received at the end of August 21 and 22. Last year, we received 33 from accountants, auditors, solicitors, and trust and company service providers, and this year it's 21. It's evident here that the level of reporting coming from this sector appears to be quite low, and it is an issue of concern. So what makes a good STR? Obviously, you're obliged to submit the STR as soon as you form a suspicion or become aware of money laundering or terrorist financing. But what we would ask is that on the report indicator that you clearly indicate, select the tax evasion option, so that we know it's identified as being tax evasion. If a client is involved in criminal activity, they will go to a lot of effort to try and mask their identity or mask who they're dealing with. So really just make sure that you've provided sufficient details on the STR to identify the individuals and ultimate beneficial owner for entities. So provide the name, full address, previous addresses if you have it, date of birth if you have phone numbers, anything that will assist us in identifying the individuals involved. Details of who else is suspected of involvement if you have it, details of any bank accounts or transactions, and the big thing is in relation to the reason for suspicion. So why are you suspicious of this person? What about their behaviour is unusual? Why is it pattern of behaviour that you wouldn't suspect this client to be involved in, and if you can set it out very, very clearly on the reason for disclosure. So what happens when we get the STRs is the STRs are data matched and risk rate on receipt before they're disseminated for caseworking. And the risk rating is based on a number of factors, including monetary value. What an STR does is it enhances the intelligence available to Revenue's investigation and intelligence team, and it's a source of intelligence. It's not evidence. So we get the information and look at it in the context of all of the other information that we have before deciding how to proceed. So what they give us is a profile of a business or an individual's activity that's not in keeping with their tax returns. So a good quality STR can therefore support an existing case, or it can produce a new case. So it can be somebody that wasn't previously on our radar. All of the information about how to register for STR reporting is available on the Revenue website. And just to emphasize again that we don't accept hard copy STRs anymore. So finally, I would just like to thank you all for your time today, and just to say that the suspicious transaction unit, the contact details are available here, and we're more than happy to provide you with any assistance we can if you need any guidance on how to submit an STR into Revenue or the registration process. So thank you again.
Thanks very much, Aisling. It was very, very informative. Just to say, as the webinar is going on, if you look at the Q&A option below, there are questions being submitted and some are being answered as we go along. Just if you have something specific or it's a detailed query, it may be best just to send an email into the unit directly. We can contact you and one of our investigators will reach out to you, and it may be best just to have a conversation, maybe something very specific that's relevant to your own business, and that might work best for everybody. So thanks again, Aisling. We'll move on to Clodagh if you're ready to go.
Good morning, James, and good morning, everybody. Hope you can see my slides. Apologies. Okay, so firstly, my name is Clodagh White. I'm a detective sergeant in the FIU, which is formerly called FIU Ireland. I'd like to thank the AMLCU for inviting the FIU to speak to you today and give you an insight into how we operate and how we analyse the reports that you send into us, and also to highlight the reporting obligations. So I'm going to discuss the role and functions of FIU Ireland, what the reporting requirements are. And again, as Aisling said, the focus is on quality STRs, and to speak a bit as well about our STR analysis process. So FIU Ireland is part of the Garda National Economic Crime Bureau. So while it sits within An Garda Síochána, it is very much a standalone and independent unit, as is required by the Financial Action Task Force. We're a police-based FIU. Quite a lot of FIUs throughout the world, they're administrative. Some are hybrid and some are law enforcement FIUs, just like ourselves. So the unit is comprised then of Garda officers like myself and admin support staff. And the admin support staff, they're in essence our compliance unit, and they are the people who process, accept and reject the STRs on the system. So the primary role or function of any FIU and our FIU is to receive, assess and disseminate reports that are suspected to be linked with money laundering or terrorist financing from designated persons like yourselves, and also competent authorities such as the AMLCU, Central Bank of Ireland, etc. So they submit competent authority reports. We use a system called GoAML. It's a UNODC IT software solution, which is used by 62 other FIUs throughout the world. So in terms then of the investigation of the actual STR-related intelligence, we have 3 in-house money laundering investigation teams. They would investigate the complex cross-jurisdictional STRs that are submitted to the FIU. We would also disseminate quite a lot of STRs to the Criminal Assets Bureau, and again, some of those could have tax implications. and also then to trained detective sergeants at each of our Garda divisions who understand the sensitive and confidential nature of the SDRs. So in terms of our functions and powers, we were put in a legislative footing with Section 21 of the Criminal Justice, Money Laundering and Terrorist Financing Amendment Act 2018, which amended the 2010 Act. As you know, all worldwide FIUs, we also need to comply with FATF recommendations, EU directives, EU regulations, and of course then the domestic legislation transposing the EU directives. So within the main FIU itself, we also have a terrorist financing intelligence unit. So again, the SDRs that come in, they can be in relation to suspicions of money laundering or terrorist financing. But again, those that come in with a report indicator of terrorist financing, or when we apply certain keyword searches and filters, if we identify something which might indicate suspected terrorist financing, then they are considered very high priority, and they're assigned almost straight away to our terrorist financing intelligence unit. And then they in turn work very closely with our special detective unit and security intelligence services in terms of the sharing of intelligence. I currently head up a unit within the FIU called the International Relations and Policy Unit. And again, as you can imagine, in the whole sphere of AML and CTF, there's quite a lot of policy, both domestic and international. We work very closely with our other FIUs, especially EU FIUs. So again, we would be attending meetings in Brussels, etc., with the EU Commission, talking about how we can all work together in the effective fight against money laundering and terrorist financing. We also share SDR-related intelligence with our FIU counterparts, again, where we have suspicions of money laundering or terrorist financing. So in terms then, more specific into our role and functions, and this is important for yourselves, where, you know, when you submit an SDR, or we might just communicate with you directly on the GoAML message board, which I'll speak about in a moment, it's important for you to understand, you know, it's not just your reporting obligations in terms of SDRs, but we can also reach out and request information from you as an FIU. So we've increased powers and obligations, and we're obliged to conduct operational and strategic analysis on SDRs. So again, it's about linking persons, accounts, and entities, identifying specific transactional flows. And again, it's all about statistics. You know, submitting an SDR is one thing, but again, what value is gleaned from it? How effective are they in the fight against money laundering and terrorist financing? You'll also have seen from Section 4211 of the 2010 Act. Again, this was an amendment in the 2021 Act, which states that FIU Ireland shall, where practicable, provide timely feedback. Now, you'll see the number of SDRs we receive annually in a few moments, but again, it's not possible for us to provide feedback on every single SDR. In certain cases where we have something valuable to share with you, we will do that on the GoAML message board, or we'll contact you directly. Also, our feedback in terms of trends and typologies, it would be in terms as well of the various presentations that we give at various fora to the private sector. So in terms of our powers to request information from designated persons, so Section 40C3 of the 2010 Act is amended. This is the power we have. So we can make two types of requests. The first one is, do you have a business relationship with a particular person? So again, you wouldn't have submitted an SDR, but we somehow have intelligence or information that a particular person or entity has a relationship with one of your entities. Secondly, we can seek additional information on an SDR already submitted. And again, you're covered under the legislation. The 2010 Act is amended to respond to those particular requests. And that's under Section 42(6)A for the additional information, and then Section 56 of the 2010 Act. We can also receive requests for information from other EU FIUs. So again, for example, the French FIU might send a request to us asking us to reach out to one of your entities to ascertain details about a particular entity or person. And what we do is, under the legislation, we use our domestic powers, 40C3, to reach out to yourselves and request that information. And then we have power under Section 40E of the 2010 Act as amended to share that information with the international FIUs. And again, just to reassure you, this is all for intelligence and analysis purposes only. So just give you an insight into the figures. When we started off in 1994, we had 199 SDRs. In 2021, we received over 35,000 reports. And we also get another type of report, as does the Revenue Commissioners, called an SDR EU report. But again, that's not applicable to yourselves. Therefore, the e-money institutions operating under freedom of services, where they send all the reports to FIU Ireland for all EU member states, and we then essentially disseminate them. So as John mentioned, and Aisling, your obligation to submit SDRs is under Section 42 of the 2010 Act. Again, the dual reporting. Unfortunately, it's not possible just to, compile a report, press one button and for it to go to both of us. There has to be this dual reporting as provided for and what you're obliged to do under the legislation. It says you must submit it as soon as practicable. And again, timely reporting is very important. It can be important, sometimes more important for the FIU, because we may have to take action, for example, in freezing accounts, etc. So as Aisling mentioned, SDRs are only accepted electronically. And again, it's important, have you registered on GoAML and ROS as an entity? So at the moment, we have 18 tax advisors registered on GoAML. So I would encourage you, following today's webinar, to consider registering on GoAML. You will then get your organisation ID, which will allow you then to register on ROS for the reporting. Again, it's important to select the correct reporting entity type. So again, for yourselves, that would be tax advisor. So once registered then on the GoAML web, you can go in then and click on the help button, and there's quite a lot of documentation there to assist you in relation to using the system, how to submit the SDRs, some trends and typologies, some alerts that we've issued, etc. Most entities submit SDRs as web reports, but there is a functionality there whereby you could do automated uploads. But again, if you're only submitting small amounts of report annually, this may not be, from a cost-benefit analysis purposes, be suitable for yourselves. So basically, whether you're going in on our system, keying in a report, or on the revenue system first to key in the report, that's how I would imagine you will be doing it. As you know, reports can be accepted or rejected on GoAML. Again, our focus, as is the focus of revenue, is on quality data. Just be careful as well, for security reasons. Your information is only available on the web for certain time periods. So there's a 7-day time frame prior to submitting an SDR. So if you start compiling an SDR today, you have 7 days within which to submit it. And once if we reject it, then you have 7 days to revert it, and then a further 7 days to amend it and resubmit it to ourselves. When you submit on the GoAML system, we would advise you to wait until we accept the report before then creating the XML, which you can upload to the revenue system. In terms of the message board, and again, we would encourage you, once you're registered, to use the message board. It's a two-way secure communication system between the FIU and individual reporting entities. So again, if you have a query, etc., please use the GoAML message board unless you need to contact us directly in urgent situations. We will send our SDR acknowledgements on the message board, any alerts, trends, typologies, etc. And just also bear in mind that there's a 6-month time frame where all your messages are available on the GoAML message board. And again, we would encourage you to check the message board regularly, but also be aware, if we send something on the message board, the MLRO or admin person is going to receive an email notifying them that something has been sent on the message board. So in terms of the quality reporting, again, Aisling has referred to it, good quality STRs are vital in the fight against money laundering and terrorist financing. And just again, from an FIU perspective, what is a good quality STR? So again, it's all about the attention to detail. And this is very important, especially in the reason for suspicion. And again, section 42.6 of the 2010 Act as amended, that tells you that, you know, you're obliged to submit the reason why you're making the report. So again, why are you submitting the report? What individual transactions will the FIU expect to see in the transaction fields? So if an unusual or suspicious transaction is worthy of mention in the reason for suspicion, then it must be included in the transaction field. So every STR must have at least one transaction to capture person, account, or entity details, which we can then do our analysis on. So there are two types of transactions. You can either select a bi-party or a multi-party. Bi-party transactions provide us with the best information on the flow of funds, for example, from a person to an account, or in terms of an EFT from one bank to another, that's account to account. But again, I think you'll agree, any of you that have used the system, bi-party transactions are most suitable for the financial sector where there's a flow of funds. But we find that STRs from the DNFBPs like yourselves, you will generally be selecting a multi-party transaction. So you may not be seeing an actual flow of funds. It could be something you've seen on a bank statement. It could be something you've seen from the records that the particular entity has submitted to you for review. So again, it could be record keeping issues. So what we would say to you is that you're more likely going to be capturing suspicious activity or unusual behavior. So what you do is then you select multi-party and you tell us about the firm. You add the particular directors who are associated with the firm. Say, for example, if you've seen bank statements for a particular entity. So again, what you do is you as part of the transaction, you select account not my client, and then you provide the IBAN, the bank name, and the account number for that particular account of your client. The entity field, again, that's very important as part of the transaction, because obviously, you know what I mean, you'll be dealing with entities and the principles of same. Attachments again can be added to your STRs. So again, there's a maximum capacity for 30 gigabytes. And again, by providing us with attachments and the revenue commissioners, that allows us to better analyze the STRs. So we obviously need this sufficient detail to perform effective analysis. And again, we may need to reach out to you for further information on the GoML message board. As you can imagine, with the high numbers of reports, and so far in 2022, our STR figures are up 7%. We need to prioritise STRs and assign appropriate risk ratings like the revenue commissioners. So again, it's important that you select the appropriate report indicator. And again, this is a suspected criminal indicator. In 9 times out of 10, you know, you may suspect something, but you won't have the evidence that a particular crime has taken place. So again, there are different report indicators. You have money laundering, terrorist financing, you might put in a PEP, tax evasion. So again, I think tax evasion, as Aisling said, is the more likely one that you'll be selecting, but you can select more than one. Once the reports are processed on GoML, then the system automatically links and merges. So again, it's important that we receive accurate data. So again, as part of our analysis, what we do is we try to see, can we link the person and or the source of funds with a particular predicate offence or profit generating crime. So we do law enforcement checks, open source checks, and again, given the cross-jurisdictional nature of money laundering and terrorist financing, we will conduct international inquiries with our FIU counterparts. And again, a substantial number of STRs, especially from the financial sector, they will have international links. So again, the STR related information, if we have a criminal indicator, we will disseminate that, and we're covered to do that under the legislation. We disseminate that to law enforcement, and most of the STRs that we receive where links with criminality are established, the STRs are mainly from the financial sector, and they relate to bank accounts where proceeds of financial crimes are being laundered. And again, you'll all be familiar with, you know, we had the Financial Crime Awareness Week at the end of March and early April of this year, which was run by the Garda National Economic Crime Bureau, highlighting the increases in financial crime. And again, they're being channeled through Irish bank accounts, mule accounts, and also business accounts. So again, this is important for yourselves, you know, to know what's normal or what you expect to be normal for your clients, so that you might be able to, through the monitoring process, identify unusual or suspicious activity, transactions, or behaviour. As I mentioned earlier, there is a necessity to protect the source of SDR-related information, as SDRs are confidential. Similar to revenue, they're used as a trigger to instigate an investigation. And again, whether it's members of the Criminal Justice Bureau or members of Garda Síochána, they will actually then come with a court order to yourselves and uplift the relevant documentation formally and foot up court orders if that's needed for evidential purposes. SDR-related intelligence can also be used to support ongoing investigations. And again, you know, the Criminal Justice Bureau would regularly come to us to see if we've any SDRs on particular persons of interest. And again, these SDRs may identify tax-related offences. We have a low number of reports from tax advisors. And again, it's difficult for us then to identify particular trends and typologies as a result of analysing those particular SDRs. But again, for yourselves, if issues are identified when doing reviews for a client, they should be reported to both ourselves and FIU Ireland and the Revenue Commissioners. And again, you need to protect yourselves from money laundering and terrorist financing risk. And again, it's important to think of your reputations here as well as designated non-financial bodies and professions. So that concludes my presentations. There's our contact details. There's our direct phone number as well if you have any queries at any stage. But again, I would encourage you to register on GoAML if you haven't done so. So thank you very much for your time.
Thanks very much for that. It's very interesting, very informative, and hopefully we'll see an increase in the number of tax advisors that are registered. It is something that our inspectors will look at when they go out on an inspection with you and talk to you about, and encourage everybody to ensure that they're registered on GoAML and ROS, and that you're all aware of your responsibilities under the in relation to SDRs. So that's an important thing that we will look at when we go on inspection. So it's as well off to do your registrations in advance and do it now, so you're able to report as soon as possible. So thank you very much, Clodagh. We'll move on, last but not least, to Mick O'Connor of the Revenue Commissioners.
Thanks, James. You can hear me, yeah?
Yeah, go ahead there.
That's grand. Firstly, just to say thanks to yourselves in the department and to all the advisors here today for the opportunity to give an update on the Central Register of the Beneficial Ownership of Trusts. And really the purpose of our slides today is to raise awareness of the obligations under the Trusts Register. Firstly, I suppose revenue was given responsibility for the Trust Register. Again, it's there under the anti-money laundering and terrorist financing legislation. It's important that people are aware of it. And obviously recent world events show the importance of all of this legislation anyway, and the purpose of it. So I suppose just looking at what we have here on it, we have some of the legislation there in terms of the background. But the key point of the register is the purpose. So it's to provide transparency around beneficial ownership of relevant trusts. And you can see there, a relevant trust is an express trust established by a deed or other declaration in writing. There are some what are called excluded arrangements, and they can be found in section 106 ZC there of the Criminal Justice Act of 2010. An express trust is one established by deed or other declaration in writing, where a settlor has clearly declared that identifiable assets have been placed on trust for the benefit of certain beneficiaries, and there are obligations then on trustees to file relevant trust details on a central register. And it says here to keep the registers up to date. And the reason it says that is trustees are meant to keep their own internal register of the beneficial ownership of the trust, and then they're meant to have a filing obligation to ourselves in the central register. And that obligation that they file is they must file within 6 months from coming into existence. And obviously, trusts that were in existence prior to April of 2021, the first filing date for them was November of last year. So existing trusts should really have filed at that date, a new trust then within 6 months of coming into existence. So I touched on the fact that there are two registers. So the trustees are required to provide and hold up-to-date information on their own internal register, and then provide the information to ourselves on the central register. Regulation 7 outlines the information that they should hold on their own beneficial ownership register, and Regulation 23, what they must provide to ourselves. Now, I know we've jumped ahead just a little bit there, so don't worry that the slides will be available to people afterwards with those regulations. But the key point in terms of the internal and external register, if you want to think of them that way, is that they should be the same. The information should be the same on those. In terms of due diligence, which is the reason we're speaking here today, we have the regulations there set out in writing. But the key point I'd like to make to people is that trusts feature in a wide variety of customers. So just to have that awareness, and it ranges from non-profits to large financial transactions. Trusts are used during bond and debt issuances, but they can also be used by your local sports club and charity. So it's good to be always aware that your customer structure may include a trust. And that due diligence process is not just by yourselves, but it's by financial institutions as well. And so more and more, you'll see that as this beds down, some of your customers will be asked by other bodies in terms of their register. So it's good to raise awareness amongst yourselves and amongst your clients. So the regulation says there's an obligation on the trustee when entering a business relationship or occasional transaction with a designated person to provide information on the beneficial ownership of the trust. And the designated person may also request this information from the trustee. Section 35(3) then of the 2010 Act places an obligation on a designated person when entering a business relationship with a relevant trust to find out what information concerning the beneficial ownership of the trust is entered in their own beneficial register or in the central register of the beneficial ownership of trusts, as the case may be. And when they're doing that, if they find a discrepancy between the registrations or that there is no register, they should be notifying ourselves by way of a discrepancy notice. So access to the register, then in terms of managing the process, the Regulation 27 gives designated persons access to a trust information for due diligence checks. And for data protection reasons, the way that we manage that is that the trustee provides that access to the person doing the due diligence, and they will provide an access number and a trust registration number which allow access to the register. That access is time bound for 14 days, and the screenshot there shows where the access can be provided from. So essentially, the control of the access is with the trustee, but the important message for the person doing the due diligence is obviously if they fail to provide that access, that is obviously an issue that you need to take on board. In terms of discrepancy notices, then Regulation 22 places an obligation on a designated person, as it says there, to deliver in a timely manner a discrepancy notice to the registrar, to ourselves, where they form the opinion that there's a discrepancy between the information contained on the internal register and the central register. We'll then consider and apply the notice in line with the regulations. Regulation 36 states that a designated person who fails to deliver a discrepancy notice commits an offence and is liable on summary conviction to a Class A fine. I suppose one of the questions we've had during the last year in dealing with external bodies is what differences should be reported. So it's only material factual differences should be reported. And obviously in the Irish context, we all know lots of people have slight variations of their names. And the key test you have to ask yourself there is the slight variation in the name to prevent identification of the beneficial owner or not? If it is, well then that's a problem. If it isn't, it's just normal business. There is a form available on our website, the SIRBOT discrepancy form, and you can submit that then through My Inquiries. We're going to just give a little bit of the information here that's provided to designated persons. So the name, the beneficial owner type, the month and year of birth, country of residence, nationality, nature and extent of interest held. And just the last point, information relating to a minor is not disclosed. Now, there can be exceptions to that, which we'll touch on in the next slide. So if we just move on to the next slide, it sets out what happens when the beneficial owner is a minor. So information relating to a minor who's the beneficial owner must be requested of the registrar in writing. Again, there's a form available on our website, which you'll see there. And I just want to say our website, obviously, as Revenue is responsible for SIRBOT, the SIRBOT information is hosted on the Revenue website. So you'll find it there on the home screen when you go down to the bottom. You can get the form and submit it via My Inquiries on Ross. And you must contend why it is in the public interest that minor information must be disclosed. And I'll just make a small point there in terms of we have had a number of requests on this, and certain bodies are just simply referring to the legislation rather than providing us a substantive reasoning as to why it is in the public interest that minor information must be disclosed. On receipt of the application, I'll consider the application and respond essentially with a yes or no, depending on the case that is made and the circumstances of the case. So I suppose just in terms of a wrap up then for people, that's a screenshot of where our information is held. You can go there, you can raise an inquiry if people have any questions. Obviously, we're happy to hear them. You can raise them through the website there. But the key message for today, really for yourselves, is to be aware that we're there, to be aware of the obligations, and to be aware of just how wide-ranging trust legislation is, and the fact that entities that you may not consider automatically to be within this regime may well be. So an express trust in any circumstances is something that should make you think about this process. And then unless it's in one of the excluded arrangements, you need to follow through and make sure that things are in order. So look, with that basic message, James, I'll hand back to yourselves. And again, thanks for the opportunity.
Thanks very much for that, Mick. No doubt there's plenty of information on the Revenue website. I know it's fairly comprehensive in what they put up there. So I just want to take this opportunity to say thank you to everybody who's participated in it. It's much appreciated. Thank you to all of you for joining us today. And I just want to say a specific thank you to the events team in the Department of Justice, to Roisin, for doing the background work, for organising all of this. It's been great. They've been very, very helpful to me. I hope you have all found this very beneficial and informative, and it'll help you meeting all your obligations going forward. Thank you.